Welcome to the Eversheds Sutherland Inquiries and Inquest podcast. I'm Angharad Hurle, Legal Director specialising in inquests, inquiries and confidential investigations. Today's episode is titled, Are there differences in the role of counsel to the inquest or inquiry? I am joined in this episode by Sophie Cartwright KC, a barrister from Dean's Court Chambers. In this episode, we discuss the role of counsel to an inquest or inquiry and whether there are any fundamental differences, to include the impact of converting an inquest to an inquiry. Thank you for joining me today, Sophie, to discuss the role of counsel to an inquest or an inquiry. So you have significant experience of both counsel to inquiries and complex inquests, to include the Manchester Arena inquiry, Andrew Wilkinson, Jalal Udin, the Anthony Granger, and also the COVID-19 inquiry. So from your experience, what are the key differences between being counsel to an inquest and counsel to an inquiry?
Okay, so I would probably say there's very little difference between acting in both roles. Okay. And perhaps if you look at the Chief Coroner's guidance on counsel and solicitor to the inquest, so guidance number 40, essentially that references the case of RV Secretary of State for Northern Ireland ex parte Devine and Breslin, where essentially it identifies that the role is analogous, whether you're acting as counsel to an inquest or counsel to an inquiry. Broadly speaking, when you're acting as counsel CTI, and I'll use that globally for counsel to the inquest or counsel to the inquiry, you've been instructed because of either issues of volume, complexity, or sensitivity, and your role is to act as independent counsel to assist the coroner and or the chair of the inquiry in terms of their terms of reference if you're an inquiry, or the scope of the inquest if you're an inquest. So really I found that when performing both roles, there's actually no difference to about how you go about the task. Yeah. And I also think fundamentally there's a really important role for CTI to really assist with the logistics of speaking to the other parties, whether they're represented or in person, to ensure that the sort of case management behind the scenes that you can undertake as independent counsel, that the chair or coroner can't do in terms of entering the fray, but that can assist as well with proper case management. So my experience would be, actually there's very little difference between how you conduct yourself. Obviously you have to operate within either the statutory framework of an inquest, or if you're a statutory inquiry, within the Inquiry Act and inquiry rules. And so that's sort of a broader framework that governs what you're doing. But I actually have found that there's no difference in reality between when you're doing the role.
Yeah, I think that's also our experience from a solicitor to the inquest and inquiry role as well. So whilst obviously they are different in terms of the ultimate aim, they are both inquisitorial, and our role as solicitor to an inquest or an inquiry is just to ensure that you as the counsel gets the information that you need, the chair or the coroner gets the information that they need in the most efficient way. And as you say, a lot of it does come down to the management of that as well, doesn't it? And the case management that goes on in the background and the liaison between the different parties.
No degree. And can I ask you from your perspective, Angharad, because I know you and also Eversheds more broadly have had the privilege of acting as solicitor to the inquiries in both statutory and non-statutory inquiries. Do you find that when you're acting in that capacity, there's any changes or differences between the role of solicitor to an inquiry when it's statutory or non-statutory?
I think a lot of it does depend on the terms of reference and how narrow or wide they are as well. But ultimately, we are there to try and make the process as smooth as possible for everybody involved. And that's not just the chair or coroner, the counsel team, but also those interested parties or the core participants that are involved as well. And the main difference between the non-statutory and statutory element, obviously you've got the Inquiries Act and inquiries rules for the statutory inquiries, so you have got that extra bit of flexibility with the non-statutory. And while some people will say that the when you're actually trying to get the information from people, just having that statutory power and the ability to say, well, if you don't provide it to us, we have got these statutory powers, working with the individuals or the establishments that need to provide that evidence to us is key in both. And I think that's one of the main things that we find is actually, I think we will keep coming back to this point about the relationship between all the parties that are involved is actually really, really important. In terms of when an inquest is converted to an inquiry, do you see much difference in the roles there?
Okay, so I've been involved in 3 inquiries that started life as inquest. So I was originally instructed as counsel to the inquest. And as you've already mentioned in the introductions, there was being the Jermaine Baker inquest that converted to an inquiry, the Anthony Granger inquest, and also the Manchester Arena inquiry that started life originally as an inquest investigating the deaths of the 22 individuals that died following the Manchester Arena bombing in May of 2017. And so obviously when we were in inquest, we were discharging the scope of the inquest, and in each of those inquests, Article 2 was engaged, bearing in mind the relevant background and circumstances. And part of that relevant background information and evidence was PII material or secret or closed material that had to be considered and reviewed, but also then was the subject to PII rulings, which essentially meant that there was relevant evidence that couldn't be considered on an inquest because there was no ability for closed hearings. And that's in each of those circumstances, following that sort of process of consideration of PII and PII rulings, because there was relevant information that would therefore not be considered, it was necessary to write to the relevant Home Secretary in each of those inquests to request a conversion. And so in terms of then if it was different or there was a change, obviously as part of the preparatory and investigatory work as an inquest, the role of independent counsel was to review that material to help the coroner at that stage to consider PII matters in a way that would then need to be properly considered evidentially. So we couldn't do it as an inquest. So it is different insofar as when the relevant Home Secretary then accepted in each the need to convert, the difference being that in each of those inquests that converted to inquiry, there was then the ability to hold closed hearings so that evidence could be explored. And then obviously following on from that, the chair was able to either gist out relevant information or certainly confirm in respect of relevant findings that obviously that had taken account of the evidence that was heard in closed, and obviously separately closed reports are issued also. Yeah. So I suppose it is different in that scenario insofar as you can properly have the forensic exploration in a closed hearing of that material, and so that is different to obviously what you're able to achieve on an inquest, where obviously you can do preparatory work but not the actual closed hearing itself.
Yes, and then in those instances where an inquest has converted to an inquiry, do you think there is the risk of duplication there, and duplication of work?
So no, I wouldn't say so. I mean, perhaps by way of sort of to take it back a little, certainly often when there is a process before you get to an inquiry, I think there's definitely a benefit for the proper preparation where there's closed material to in a timely way consider that material. But then I don't think there's duplication, because essentially in each of the inquiries that then took place following the inquiry report, which was essentially then addressing the relevant issues that would have to be addressed on an inquest, in each of those cases there was no resumption of the inquest after the inquiry. So you ensure that your inquiry report discharges the function of the inquest and ensures that the report itself is drafted in such a way that it's clear that it's satisfied the Section 5 requirements of the Coroners and Justice Act, but also you're recording the relevant medical cause of death. And inevitably on an inquiry, the recommendations are essentially addressing the prevention of future death issues that you'd have on an inquest. So, I mean, there could be a scenario where there was a call that there needed to be a resumption of an inquest at the conclusion of an inquiry, but in reality, you ensure that the inquiry performs that role. So in reality, there's no duplication.
Yeah.
And in terms of going back to the sort of the start of the process before you convert, I don't see it as duplication, because necessarily you've got to case manage the PII material whilst you're in inquest, which then gets you to the request to the relevant minister, in these cases the Home Secretary, to convert. And so it's not duplication, it's just the necessary process and steps that have to be gone through to get you to the request or the realisation following PII that there needs to be a conversion to an inquiry.
Yeah, so I think just on that, in terms of fulfilling the duties of the coroner, essentially when it has been converted, so you've got the scope of the inquest initially, but then when it's converted, you have the terms of reference for the inquiry. And if you've already had that element of preliminary investigations, if we can call them that, as part of the inquest, they can help form the terms of reference, can't they, to ensure that the chair is then mindful to consider fulfilling the obligations of the coroner to try and avoid the need for resuming an inquest at the conclusion of the inquiry.
No, I definitely agree, and I've not gone back and looked at the scope and the terms of reference, but I'm pretty confident that in each of those cases, what had been the defined scope of the inquest became actually the terms of reference when they were promulgated by the relevant minister. So essentially, it just was the same, essentially, terms of reference, the same scope, but just using the different statutory framework to govern the process.
Yes. And do you think when inquests convert, there can potentially be an element of confusion for some of the families involved? And if, they have the wider complexities of PII information, for example, to a family, they just want to understand what happened to their loved one who is now deceased. Do you, or from your experience, have you had any difficulties or had to kind of bring the families on that journey with you?
So again, in each of the cases where I've been involved, the families have all been supported by really experienced inquest solicitors. So they've got the benefit of experienced solicitors and also counsel, where essentially we're working collaboratively so that the families understand the process. Inevitably, excuse me, this process factors in delay, which is always stressful for families where they want to know answers. But equally, the flip side of that, I think many of the families in these cases, they don't actually mind about the time the investigations take, because what's most important to them is that there's a proper investigation and it gives them the answers that they need. So in terms of then confusion, I would say my experience is not. The hope is that both the knowledge of how they're being supported by experienced solicitors and counsel, but also then the role you have as independent counsel, where you're still having that liaison with families and family teams with their legal support, is to hopefully give an assurance that as to why the process is taking time, or to reduce the confusion. And equally, each of the chairs that have managed the conversion process, I think they're pretty clear in their case management of it, why it's having to convert. So there's clarity there in the rulings that have been given. But I think equally the benefit of independent counsel when you're acting as CTI, when you do convert, in the knowledge that there are these closed hearings where their own legal representatives, who they've plainly got trust and confidence in, are not permitted to be present. I think that's where independent counsel's role is really important, that the work that you do to show that really you are working independently to investigate, so that they have the trust and confidence that even if their own solicitors and counsel can't be in those closed hearings, a confidence that essentially as CTI that are in those hearings are essentially exploring issues that the family would wish to be explored, even if they and their legal representatives can't be there. And so I think that's another important role of independent CTI, getting the trust and confidence of the family teams, so that they equally have an assurance that we are essentially exploring issues that are of importance to the families when we are enclosed. And so I think that also helps as you move along. So the hope has been that there's not been the confusion as to why things have had to convert, but equally When it does convert again, I think that's an important thing around the confidence in CTI. And I think so if CTI are doing their job well, most families, even though there's plainly a tension and a frustration that their lawyers can't be essentially in the room and at the table, I think most of the time it's been understood why that's happening and why that has to be that way. So I would hope that's the position. I hope I've not misrepresented families' experience of the various inquiries that I've been involved in. And plainly there's a tension at time, and plainly the families want to know every single last bit of the background as to what is the relevant factual background. So it is difficult, and understandably difficult for families, but also for the legal teams, to be not fully cited on the PII material. But my understanding is the process is when there's confidence in CTI, but most importantly confidence in the chair, you find a way around it. And certainly I think the experience of, I suppose, the most significant one, the Manchester Arena inquiry, certainly the overwhelming impression that I have from the family's experiences is that they had just that complete confidence in Sir John Saunders and his management of that, but also understanding of his findings in that context.
So there's an awful lot, I think, both in the roles of counsel to an inquest or inquiry and solicitor to both, in actually managing expectations of those involved. And whilst we can say we've got the scope of the inquest or the terms of reference, and these are the areas that we are investigating, and we have to remember as well that obviously these are inquisitorial processes, they aren't adversarial. And I think that is also something that takes a lot of managing at times to ensure that all involved, the core participants and interested persons, understand that there can't be any criminal findings as a result of an inquest or inquiry, but it's just managing the expectations of all of those involved as well. So how have you found that as CTI, just doing everything you can to say you are doing everything you can to get the answers that they're looking for?
So I mean that can be a tension in contentious inquests and also in inquiries. I think I suppose it's that fine line between it being inquisitorial and something crossing into adversarial, not having cross-examination, but equally there are questions that need to be asked and covered and addressed robustly, and that's not cross-examination, it's just part of the necessary forensic process to be discharging your inquisitorial duties. So there can be a tension, and I'm sure that many people have sat through inquests or inquiries where they don't see the difference between the questioning style with some witnesses as to how that's different to a cross-examination in civil litigation or in a criminal trial. But I suppose the assistance, I think, in both roles, where if there is an occasion where you might have to slightly suggest a change of approach, is the competencies that exist. So they're the coronial competencies that were issued. So it's joint guidance by the Bar Standards Board, the Solicitors Regulatory Authority and SILEX, that sort of sets out parameters about the role of all advocates at inquests. And it's really helpful around the sort of style, but also the fact that these competencies are enforceable as well. And equally, because obviously an inquest is inquisitorial, I don't think I've never expressly heard anyone reference them within an inquiry, but on one view there would be no reason to prevent you doing that. But I think that's a helpful document if need be, that sort of roots things back in the inquisitorial process and the difference in the questioning style, the need to appreciate issues of vulnerability, and particularly the impact on those who are sort of bereaved, that extra concern about how you conduct yourself. So I think they're helpful to always be aware of if you ever need it to, rein things or draw things back a little. So yeah, I mean, and it's finding that balance, and then there may be times where probably questioning slightly crosses the line, but equally, if it's short and measured, there may not be a need to sanction, because again, it's that balance. I mean, and that's ultimately CTI have a role, but equally that's then the chair's role or the coroner's role to essentially be conducting and managing their own process. And so, certainly what I've seen in the management of chairs in inquiries, if there's ever a need just to slightly ask, the question to be asked in a different way, that it can quickly bring things back online. And I touch wood, I don't think there's been no major fallings out in terms of the inquiries that I've been a part of where there's really been a need to take it further.
Yes, I think from my experience of sitting in various hearing rooms, and when you hear counsel to an inquiry and inquest asking questions, and you can see that tensions are starting to rise slightly, the chair's role there, I think, is really important, and they're often very quick to step in any event and just say, oh, let's just rephrase the question, for example. So if you could give us a top tip, as it were, what would your top tip be for how a solicitor to an inquest or an inquiry could assist you to ensure that your life is made easier?
So again, I think it's almost the other way around. I've had the privilege in each of the inquiries I've worked on where the solicitors to the inquiries are absolute leaders in their field. Yes. The knowledge and experience they have is way beyond the sort of experience on terms of the management that they have to do and the extent of correspondence they have to enter into the management. So I would feel wholly wrong to be suggesting a top tip to any of the solicitors inquiries that I've worked with, because my experience is just deep respect for their knowledge and experience, but also the mammoth task that they have managing the many and varied issues. And I'm sure, Angharad, you've completely found that in your work. It's a really unique role. It's incredibly labour intensive. I mean, the best example I've got is, you just see the emails that are being churned from the get-go, because I think solicitors inquiry, it literally is unrelenting, the amount and volume of correspondence that's having to be managed and issues to keep on top of, particularly when solicitors inquiries have, their role on costs as well, and section 40 funding. So I wouldn't even dream of suggesting a top tip to any of the solicitor inquiries I've worked with. It would be the other way round. I just have deep respect for how they discharge a very, very difficult labour-intensive task. And I think it's unique individuals that discharge the role of soliciting inquiries. And I suspect you'll find it yourself with Eversheds and the other firms that do this work. They get the repeat instructions because they are truly expert in this field. So it's not about reinventing the wheel. It's just people that are very, very good at managing these complex inquiries and inquests. Yeah.
No, I agree that there is an awful lot there as a solicitor to an inquest or an inquiry that you are juggling. But I think from our perspective, I think communication is really important between everybody involved. So, to have regular meetings with the counsel team or the lead counsel in particular, the chair, the coroner, and also the other parties involved, being the interested parts, the persons or the core participants, and just communicating and explaining what is actually happening and what's going on, because there can be months of silence as you're gathering evidence. And unfortunately, outwardly it can appear that actually the solicitors aren't doing much. But in reality, we are running around quite a lot in the background. So I think working together and working as a team, both internally, if I can call it that, as the chair, coroner or CTI and solicitors, but then also externally with those involved and the interested parties, I think is actually very important as well.
Definitely agree with that. And I think, lots of inquiries have a structure in place where even in those periods where it's a bit like the hamster wheel, there's a lot going on, that, the structure of a monthly update can often really help in terms of addressing what's been going on in the months between hearings as you progress towards your final inquiry hearing.
Yeah. Well, thank you very much for that, Sophie, and for your insight into the role of counsel to an inquest and inquiry. I found that very interesting. So thank you very much, and I'm sure that the listeners will also be very grateful for your insights.
No, and thank you for yours also. And it's been nice to chat to you today, Angharad.
Thank you, Sophie.